It's fun time. The Supreme Court, and you are on the Supreme Court, and a statute's constitutionality was challenged. What standard of review would you want to employ?
Well, I think that the law really dictates what the standard of review is that the Supreme Court applies to constitutional questions. We review those questions dependent upon that standard of review, and it really depends on what kind of question it is. Sometimes those questions are what we review in a manner called de novo, which means we look at it brand new. Other times, if it involves questions of fundamental rights, we apply what's called strict scrutiny. So it really depends on the kind of question that comes in front of the court. In terms of constitutional questions generally, and I've had the experience over the last several months of being on the court to hear cases involving the interpretation of the Constitution, but I've also served as a tribal court judge for many different tribal courts, all of whom had their own tribal constitutions. And so I've had years of experience interpreting and thinking about constitutional law and what it means to apply the Constitution and how that impacts the people the Constitution affects. So what I believe that we should be doing as a Supreme Court is looking at the words of the Constitution, looking at the intent behind those words, and applying those concepts to the issues that come in front of the court in a way that looks at those issues as current living issues. There's been a lot of discussion, as Tony said, about the way in which we should interpret the Constitution, and that conversation has been a very live one nationally. I think that my view of our Constitution is that it is a living document, and we should interpret it as such.
Okay, Judge Larson, do you need the question repeated?
No,
I have a follow-up for Justice Montoya-Lewis. May I ask that follow-up question? Yep. Okay. So you said that there are two standards of review typically, and you explained de novo and the further strictly scrutinizing one. Is there a preference that you see yourself applied to cases that come in front of you? And if you have a preference of one over the other, why?
30 seconds.
Thank you. I wish that I could say that there were only two approaches to constitutional standards of review. There are many more than the two I described. They were just examples. So my job is to follow whatever it is that applies. I'll give you an example. Something that is related to racial discrimination that might be in a statute is reviewed by strict scrutiny. And there are others that are reviewed by what's called a rational basis, which is the lowest bar there is.
That's it.
Thank you.
Mm-hmm. Judge Larson, Judge Larson, do you need to hear the question repeated now, or are you good?
No, I can respond. And I think Justice Montoya-Lewis it's very difficult to answer that question in 2 minutes. And Justice Montoya-Lewis did a good job, especially the follow-up, because there's multiple tests.
You got 2 minutes.
So I'm not going to repeat what she said. But I will say I think that for public trust and confidence, there needs to be consistency in how you apply it. And I'll bring up the example, and a lot of people, it's a political issue, but it has to do with I-976 and the recent decision, in the sense that the court upheld I-776 in 2003, which is similar. And the court would say that they were different, but they're very similar. But the point is that there's a good argument that they didn't apply the Constitution consistently between the two cases. In 2003, they held the $30 car tab to be constitutional with a different set of justices. And now they've declared it unconstitutional when it's very similar. And so that's what creates sometimes the rift with the public, is if there doesn't seem to be some consistency. Now, reasonable minds can differ about whether there was consistency, but that's what causes the rift. So I think making sure you're consistent in terms of how you're applying your reasoning to the Constitution contributes to this sense of trust, because if people trust your decision, they're more likely to follow it and respect it. and they'll feel that there's some balance. Otherwise, there's this public debate that continues, that's continued for years in that particular issue, that's never resolved because people don't think that the decision was resolved fairly. So that's my take on it, that it needs to be consistent.
Should individuals be allowed to use reasonable force to resist an unlawful arrest?
1 minute.
Thank you. That's a great question. I think as many people of color, I was raised to follow the directions of officers, lest my life be at risk should I not do so. And I continue to follow that rule even in the position that I'm in today. I think it puts citizens at great risk to do that. And I think that the appropriate thing to do is to challenge those arrests in the court system because of the potential of harm to the individual, harm to the officer, and the potential consequences of that. I understand the reasoning why someone would choose to resist something they believe to be unlawful, but I think that that's appropriate for the trial court to decide.
Okay. We'll forfeit the last 10 seconds. And Judge Larson, do you need the question repeated, or can you go ahead and answer?
No. Legally, it's legally somebody can use reasonable force to resist an unlawful arrest. The question is whether it's wise to do that. And as Justice Montoya-Lewis said, what I've done in my community is and I'm waiting till after the election so it's not seen as political, is I've got the Black community and the police to agree to talk to each other, to educate about the rules of engagement, and to law enforcement to listen to how it feels to be approached in a hostile manner by law enforcement, how that might contribute, and then also educate the rules of engagement when it comes to when you're confronted with law enforcement. It's good for everybody to know, but the bottom line is getting that understanding, getting that trust among people. In addition, I've got them to agree to cooperate in reducing gang involvement, and that's some of the things we need to do with our communities is get that communication going, getting that trust, because the trust and the lack of trust right now is what's driving most of what we see.
The Supreme Court adopts new rules. Do you think there should be changes to rules? And an example would be, what do you think of the rule that limits caseloads for public defenders?
Well, I sit on the Rules Committee for the Washington State Supreme Court. We review rules of all kinds all the time, and it's a critical part of what we do. With regard to your question regarding the caseload requirements, I've spent a lot of time with public defenders over the course of my career, as well as prosecutors, and public defenders are always overworked, including with these caseload limits that we see today. It's a step in the right direction, and it is part of our job, I think, to ensure people have appropriate representation. As far as rules that I think need to be addressed and changed, I think we have a long way to go to ensure that we have jurors who represent the community. And that's something that I think our rules can begin to address as we move forward.
So Judge Larson.
There needs to be changes in rules. We need to do something about local rules because they're out of hand. That's causing a lot of issues. Not many people are even aware of the local rule issue. With regard to that particular issue, we need that. But we also need to look at how we compensate public defenders, because there's a discrepancy between how prosecutors are paid and public defenders are paid. And I think that creates an equity issue in the system. We also need to figure out how we can get them on a retirement system so we can keep people in the practice of public defense for longer than what we do. And but as far as rules, I think the rules contribute to the types of things, the expense, the cost, the complexity. We really need to look at how we simplify things to make, and especially in family law cases, to simplify things even more than they are now, to make it so it's easier to navigate the system. One of the things that was eliminated was the limited licensed legal technician program in June. I'd fight to restore that to help people
and that's time.
Navigate.